Welcome to the Smart Strata educational webinar. Today, we're here to discuss the importance of how to deal with the impacts of COVID-19 for our strata communities. I'm joined by two industry experts, Grant and James, and I am Nikki Lonergan, CEO of Archers of Strata Professionals and your MC for today. Throughout the year, Smart Strata hosts educational seminars to keep our body corporate committees informed. We are trying this new format because of social distancing and the fact that we can't hold large groups, but we endeavour to do our face-to-face seminars next year. Thank you to our industry sponsors who have delivered their expertise and support to our customers during this time. I'd like to acknowledge them now. They are Archers of Strata Professionals, Marsh Advantage Insurance, ARC Utilities, Strata Compliance Solutions, Poolworks, ThyssenKrupp Elevators, that one always gets me, Program Property Services, Strata Loans and Chambers Russell Lawyers. Thank you to our webinar partners who have generously provided some gifts, and they'll go into the prize draws that we'll be drawing out over the next week on our Facebook page. Additionally, we have, for one lucky winner, this Google Home Hub, and that will go to somebody who has donated their time in responding to what they'd like to hear today, as well as attend the webinar rather. We are grateful for all that participated in the survey, because knowing what you want the answers to helps us provide you with educational content that's of relevance. Our goal from today is to empower you. As body corporate committee members, we know that making the right decisions can sometimes be a struggle, especially in such uncertain times. We want you to walk away from today with a list of action items that you might take back and implement in your building. After this webinar, we're very happy to take your calls or your emails and assist you in any way we can. So if you need to contact us, there's details on the screen right now, and our telephone number is 07 5458 4537 or email info@smartstrata.com.au. Today we're welcoming to our virtual stage two strata industry professionals. These two professionals contribute to the industry a significant amount and have been in our industry for a long time. Not that they need introduction, but I will go through with you who I've got here with you. So I have James Nicholas, who is the President of SCA Queensland, our industry peak body. He's also a partner at Chambers Russell Lawyers. Welcome, James.
Thanks, Nikki. I'm happy to be here.
Grant Musford, a partner at Archers of Strata Professionals. He has also been in the strata industry from 2002. He carries a wealth of knowledge, is also the Vice President of SCA Queensland, and is the founder of Smart Strata, the initiative bringing you this webinar. Welcome, Grant.
Thanks for having me.
Before we get into answering your questions that we've received from our subscribers, we wanted to provide some general information to you about the strata industry. So this is so our answers have a little bit more relevance. James, would you be able to provide us with an overview of what it's meant by strata being the fourth level of government?
Yeah, certainly. Thanks, Nikki. It's often referred to as the fourth tier of government. I think most of our participants would be used to the first three tiers. So we all know that it's a Federation of Australia and we have a federal government. Then we each have the governments of the states that we live in. And then we have our local authorities or local governments in our council areas. And if we look at it that way, strata is a fourth layer where decisions need to be made, and they comply with bylaws, and they have a committee and make decisions by way of general meeting.
And we're all very aware and acutely aware at the moment of how our federal and state governments are working collaboratively during this unforeseen time, which is why it sort of brings into focus how our committees and our stakeholders should also be working in this collaborative nature.
That's right. I mean, they're in a really difficult position because, as we talked about those four tiers of government, there's three layers above them that they have to be aware of when they're making decisions. So when those health directions are given out, there's a lot that they need to be abreast of, not just what's going on in their local council area or in their state.
Thank you, James. Following on from this overview, Grant, you being an experienced body corporate manager, are you able to share your insights into what the committee's role is and how a body corporate manager assists the committee with this role?
Absolutely. So the committee is made up of owners within the community title scheme, and they're elected at their AGM. Yep. They are volunteers. So that's an important thing to remember, particularly for the other owners that do put a lot of pressure on committees, and the committee members that feel a lot of pressure to I suppose, make decisions.
Yep.
When they are making these decisions, they need to consider all the stakeholders. So everyone's got their own individual positions. You may be an investor, yep. You may be a resident, or you may not be on the committee at all. So the important thing for the committee members to know is that they can rely on their body corporate manager for guidance. They don't need to know everything, particularly when it's a new concept to them, being on a committee and making decisions. Yeah. So the committee's making a lot of the decisions for the entire community. So you don't need to know everything. That's where, depending on the project, you might need to get a professional involved. But a lot of the time, you're going back to the body corporate manager, who is the expert in the industry, that knows the legislation and can provide the guidance so the committee can make informed decisions and reasonable decisions for their community as a whole.
Great point. It's difficult for them when they're looking at all of these process-orientated administrative and secretarial processes that they have to go through to meet legislative requirements, and putting themselves, one as the owner, but also as the person responsible for making a decision in the best interest of the group. It can sometimes be a lot of pressure for them.
Yeah, that's right, particularly in this current time. So there's the existing legislation, which is highly prescriptive, yes. A lot of processes, procedures to follow, which is what we are there for, to provide that guidance, provide the documentation that's going to be compliant with the legislation. So you've got a lot of different elements. There's the secretarial aspect, there's the financial aspect, yes. Then there's the administration aspect. So with the record keeping for both, from the simple things like owners' role details through to preparing documents for or financial statements for audit. We undertake all of those duties on an administration agreement.
Yes.
But then what we're doing is keeping the committee informed. So there's a lot of online processes and resources that we provide so that the committees can get all that information. Of course, the owners have access to that information as well, and they're provided that depending on, if it's an AGM, it's the documentation sent out either email or post, depending on the preference that they've provided the body corporate.
Great.
So that they can be informed of what is happening.
Yeah.
And there's certain decisions that do need to go to all owners, which is usually what happens with your annual general meeting.
That's a very detailed account. I know that a lot of the committees sometimes struggle to understand what a body corporate manager assists with, and there's a lot of items that go unseen in the background to ensure letters, documentation is correct, and we do have to defer all of our decisions to the committee. So owners may think that a body corporate manager can adjust certain elements of what's being undertaken, but the decision is always that of the committee. Is that correct?
Yeah, that's right. So the committee is there empowered, similar to the other levels of government, where you've got councillors at local, your state and federal politicians. They're elected to make those decisions. It is a bit of a thankless job because a lot of it for both the committees and us as body corporate managers, we're also committee members, but just non-voting.
Yes.
There's a lot that happens behind the scenes. So before we even seek instructions at times, there's a lot of research that might need to happen into the legislation, into the bylaws, into the history of the scheme.
Yes.
And sometimes adjudicators' orders to see if it's unclear where it might go, so that we can gather all that information, provide it in an understandable way for people that come into a committee that they might not have a legal background or a corporate background. You've got mums and dads, you've got all people of all different walks of life, and we want to be able to communicate in a way suited to
all of our clients.
Exactly, so that they can understand the information, know what the options are to make a decision, make a decision and feel empowered that they're making a decision that is legally correct, but also in the best interest financially and in the current times with the health aspects of the community in mind.
Very well said. Very well said. And following on from this, a harmonious community environment is what I perceive to be a shared responsibility. Not only do we have the committee and the body corporate manager working to ensure this legislative requirements are being met and the financial obligations are being met, there's building managers that look after day-to-day maintenance, and you've also got your other suppliers and trades that assist with the ongoing larger maintenance work for our buildings. From your experience, what's the secret of a well-functioning committee?
Yeah, so what I find one of the best ways of functioning as a committee is being prepared before you get to the meetings. So with a lot of the clients that I work with, a lot of the decisions are made before we even get to the formal meeting. There's been discussions, there's been communication, there's been background information. So, and also, depending on the situation, sometimes you need to break it up into bite-sized chunks.
Yeah.
I think we've all heard the saying, one bite out of the elephant at a time. So what we often see is that people want to bundle everything together,
yes,
and you get nowhere, particularly with, with the best intentions. It might be, whilst we've got the scaffolding out to do the painting, we'll do the roof works and we'll do the windows, and somebody wants to get access for over here and there and everywhere. What it can end up doing is, particularly what we've seen is if it's a compliance or a safety issue,
yes,
it can actually draw the matter out and become detrimental to the, we've seen orders made where a decision's been delayed because everything's been tried to be bundled in together. And an order's made to say, well, no, you need to get on with this fire safety issue or workplace health and safety issue, whatever it might be.
That's a great example. And I think there is a tendency to think, well, let's capitalise on, the expenditure with scaffolding. So that's a really good example. Just one final point on there is communication and interconnectivity of all of these different stakeholders. What do you see as the best way to ensure you can get outcomes, but they can be managed amongst all these different competing interests of the stakeholders? Yeah,
so I always advise the committees, don't feel as though you need to know everything.
Yep.
This is why if you've got a specialised project, get a specialist.
Yes.
So be it, if it's a compliance issue with fire safety or some sort of safety aspect, don't try and second guess what you need to do, particularly if you've got no experience in that area. Rely on the advice of the expert.
Timely advice. So what we've learnt is the best way for bodies corporate to perform their role, the committees, is to communicate, engage your stakeholders, and make sure you engage an expert. So I think that they're great takeaways. Thank you, Grant. Excellent. So now that we've given you a bit of a background on Strata and the stakeholders involved in the industry and the role they play, it brings us to the current climate of the pandemic and how rapidly things have been changing. There's been new temporary legislation that's been introduced to help navigate when it comes to these health and financial requirements that committees are burdened to make the decision of at the moment. This is where James' expertise comes into play. He has been heavily involved in providing recommendations on this legislation, and we're very lucky to have him today. James is going to give you an overview of the new legislation, and Grant's going to provide you with some practical scenarios so that we can put it into context for you. So over to you, James.
Thanks very much, Nikki. I guess the best way to think about this legislation is that it's enabling legislation. So when the pandemic first hit and banks were doing certain things to make life easier for borrowers, landlords were required to change things for their tenants. There was a lot of cry out at that stage to say, well, what about us in Strata? What relief are we going to get? And the government's role in this was a really difficult one because unlike those other situations, this isn't a situation where you've got an entity that's billing these people under a contract and can simply decide to change that easily. So this is much more like, your own household budget and deciding out of the money that you have, what are the things that are essential that you have to keep paying for, and what are some of the things that you maybe have a bit of flexibility around. So the government couldn't just make sweeping legislation to say nobody has to pay their strata levies until this is all over. But what they did do was take a bit more of a pinpoint approach to saying what are the things that are getting in the way of bodies, corporate and committees being able to administer their own affairs properly, and how do we enable that? So what they've done is introduce this temporary legislation, so temporary changes to the Body Corporate and Community Management Act and the Building Units and Group Titles Act, and that's to allow for the period of time from the 25th of May through to the 31st of December. Yep. And it addresses sort of 5 key areas. So it's to provide flexibility around sinking fund budgets. Yep. And the resultant contributions that come from that. It's to allow committees to have the ability to extend the due date for levies that may have already been struck. It's to give them flexibility around, it's to put a moratorium on interest payments during that period.
Which is a really good point, because a moratorium indicates that you must, and that we don't have the ability to make a decision on that. So it's a very important point that you make with the moratorium.
That's right. So it's essentially freezing of that interest during that period. There's flexibility provided around the recovery of body corporate debts, and also changes to the limits around body corporate borrowing. So we'll go through these in greater detail, and I'll discuss with Grant some of the practical implications around that. So starting with the sinking fund budgets, this change is to allow, by way of a general meeting, the body corporate to, in this current financial year, take a look at their sinking fund budget, analyse it and make a reasonable decision about some of those items of capital expenditure that may be able to be either reduced or removed in this current financial year. And by doing that, that will have a resultant effect on the contributions that are levied pursuant to that budget. And there's provisions in the legislation such that if those contributions have already been struck, that there'll be an ability to pay some of those amounts that are no longer required back to lot owners. And I guess the really interesting thing here is, Grant, Bodies Corporate have always had the ability to go to a general meeting and adjust their budget. It's nice that this legislation provides for it. But in practical terms, when we're talking about this temporary period, what flexibility will Bodies Corporate really have from your experience?
Yeah, great question, James. And if we stick to the sinking fund budget aspect of this legislation, essentially it's quite prescriptive, the legislation at current. What this is doing is allowing for that 1 year of the 10-year forecast, effectively, to make some decisions about whether or not those capital works items that are paid from the sinking fund are really important. Well, I suppose they are all really important, but it's more about the timing of them. So it might be painting or pool refurbishment, a lift refurb, or some sort of capital works. But what you should be doing is talking to, as I mentioned earlier, if it's a specialist area, talking to the specialists about any of those works to see whether or not they can be put off. That way you're keeping the cash longer, particularly if there's circumstances within your particular scheme where owners are having trouble paying their levies, and it's diminishing the ability to continue to pay all the other essential costs to keep the scheme running.
I think that it's a poignant comment that you may have a short-term gain by doing this and enacting, taking advantage of this new legislation. It's temporary, but it may give you longer-term pain, because those works still need to be undertaken over the course and the life of the building.
Yeah, that's right. And I think Grant's point there about engaging with the right professionals is a really key issue here. So, for the volunteer committees, how do they make that decision about what are the essential things and what are not? I mean, obviously they speak to their strata manager, but also speak to the lift service contractor. They're the people who really understand, how pressing these things are.
Correct, yeah. Good point.
Excellent. So one of the other changes is to allow the Body Corporate Committee to extend the due date for contributions that have already been struck. And so this is aimed at, again, providing a bit of flexibility. It can be done in one of two ways. It can either be done in relation to individual lots that can demonstrate that they're suffering hardship because of COVID-19, or it can just be for all lots in the scheme with no need to demonstrate that there's been any adverse effects of COVID-19. Again, Grant, given that the committee will be in a position where they can provide this relief, but as we just discussed, they've also got to be very seriously concerned about the immediate financial needs of the body corporate. What are some of the things that the committee needs to do in acting reasonably and making these decisions?
Yeah, so when you've got these levy due date extensions, so that's giving an ability for the body corporate or the committee essentially to have a blanket extension of the due date for all owners. So there was already an approval or a authority in place for the committee to, I suppose, not require payment by a particular date or extend the date on an individual circumstance, but this will give a blanket authority. So what that might mean is you might have a lot of owners that are unable to pay their levies, but there's a big decision that needs to be made, such as changing the sinking fund budget. Within the legislation, if you're not financial because you haven't paid by your due date, then you wouldn't be able to vote. So it can become quite circular. That is one of the outcomes in a practical sense that can be achieved by extending that due date for levies.
And I guess the fact that they can do that on a blanket basis, that takes away arguments of perhaps there's been some sort of favouritism or anything like that, and the committee can demonstrate that they're acting reasonably in the interests of all lot owners.
Absolutely. And just the other thing I think needs to be talked about is exercising caution. So each scheme's individual circumstances must be considered. It's not just doing it because a lot of people feel like they don't want to pay or to be fair to everybody. It's like any other bill. It needs to be paid because there's another end. The levy is collected, goes into account, and then pays for other bills that are essential within a body corporate. So caution needs to be taken with extending those due dates to consider the cash flow and solvency of the body corporate and making sure that it's not causing more problems.
Yeah, that's right. I mean, some schemes might find themselves with, building defects, emergency works that need to be done. If you've got a cracked or leaking swimming pool, then you can't simply just decide not to deal with that.
And it's a good point that you started off with, James, by saying that it is similar to your household budget. You still need to get your food and your daily expenditures, but you also need to ensure that your house doesn't fall around you or fall down around you. So it's a great analogy for committees to keep in mind when they're trying to balance this competing needs of all the different stakeholders.
And I think it helps them get away from that us and them mentality. I mean, Grant gave a great explanation before about what the role of the committee is. For lot owners to understand that this is not something that's happening to them. They have the ability to vote on budgets. They have, the ability to vote who they want to have in the committee, and it's actually that community deciding for itself how it's going to deal with this.
Great point. So we've dealt with a couple of the items. Can I throw back to you, James, to cover off the remaining items?
Yeah, certainly. So the moratorium on penalty interest is pretty important because, as we know, bodies corporate do have the ability to set penalty interest up to 2.5% per calendar month, and that can seriously compound. So what this will provide is that for debts that have been outstanding for a long period of time, that interest will have accrued up until the commencement date of this legislation. It will freeze until the end date, which is currently the 31st of December this year. and after that date, that interest will start to accrue again. So again, temporary relief, but that interest may not accrue during that period to increase the financial demands on lot owners during that time. So one of the other items of flexibility that's provided under this legislation is that the body corporate in some instances must commence legal proceedings. So once a body corporate debt's been outstanding for 2 years, the discretion around collecting that is taken away under the legislation. And they're put in a situation where they must commence proceedings to collect that outstanding levy. Now, if that was to happen during this relevant period, then the body corporate's put in a situation now under this legislation where it is not required to commence proceedings, but it may still commence proceedings. And the reason for that is to give that flexibility, as Grant mentioned before, if they're not in a situation where they can actually not collect the levies because they've got pressing urgent repairs and things that need to be done, well, then they're still at liberty to. But if that scheme can afford not to recover levies in this time, then they're not obliged to under the legislation. Grant, you were mentioning before about some of the internal flexibilities that were already in place that committees have. Did you want to expand upon those for maybe life after this legislation?
Yeah, so the interest on overdue levies was already something that the committee could decide on previously, but it was on with every decision of a committee, it does require a formal process, which is making a decision via a vote outside a committee meeting or at a committee meeting or at a general meeting if it needs to be escalated to that. So what this is doing is taking away some of that administrative burden and red tape that was in place for some of these decision-making items already, which could actually increase the cost that's already in place because you've got to hold a general meeting or send out the notices of a decision that's being made. So what it's going to look like after these restrictions finish, difficult to say, although once that decision-making power is made compulsory, particularly with the debt collection, if a scheme has for some time, and if it's been somebody that's had a debt, it's going to be before COVID-19 occurred. Essentially, it's going to be forced to start the collection action immediately from there on.
But the committee will still have some flexibility in terms of reaching payment arrangements, being able to decide whether they do in fact apply that penalty interest or whether they do in fact apply the reasonable recovery costs and things like that. And what would you say to those committees about making those decisions reasonably after this time?
Yeah, case by case basis. And asking for information about why they're asking for relief. So the owner that is in debt isn't obliged to provide that information, but it's only going to help their case. So there's within other circumstances, like with rent relief, there's an obligation under that legislation to provide evidence of job loss or some other situation that is occurring that's causing the requirement to need levy relief. So at Arches, we've put together on our website a particular form that provides all the sections and ability to provide the information needed for a committee to make, going back to what I mentioned before with decision making, all the information that can be scrutinised to make a reasonable decision for those circumstances.
Great. And that leads us on to the next point, which is around body corporate borrowing. So the changes in the legislation have essentially doubled the limits for body corporate borrowing without the need to go to a general meeting for authorisation. So in small schemes, that'll be $6,000, and in all other schemes, that'll be $500 per lot. Obviously, body corporate have been able to borrow for a long time. I think one of the other things that's convenient about the levy relief provisions that we just discussed is that when a financier is considering a body corporate's application for finance, because that's an unsecured loan essentially, the creditworthiness of the scheme is really the lot owner's ability to pay their levies as and when they fall due. And one of the things that I know at SCA we were concerned about was, would schemes find themselves with this black mark on their name, having, you know, a lot of outstanding levies, and then be unable to avail themselves of the financial relief of getting funding in by way of a body corporate loan. And I think this legislation goes some of the way to sort of dealing with that. In your experience, Grant, how many of the loans come within, or how many are likely to come within these new limits of $6,000 or $500 per lot, and how many would probably need to go off to a general meeting anyway if you...
Yeah, so what we've been seeing in the past is they usually go to a general meeting because they're for a particular project. And that project has come about with the lack of funds because it hasn't been planned. If it was planned, it would have been collected within the sinking fund over the time required. Or it might be some sort of emergency spending. So it might be something that's happened in the interim. So this is, again, relieving some of the administrative burden and red tape that's going to reduce the costs in some cases of general meetings. But yeah, whether it's going to solve the problem, as Nikki mentioned earlier about the short-term gain but long-term pain, particularly with these loans for strata being unsecured, they come with unsecured rates. So that's something that needs to be kept in mind. So whether or not you want to go down that track, there's the options of special levies. I know that's a bit of a dirty word in the strata industry, but sometimes it's required. Exactly. And it's also a commercial decision that the body corporate should be making based on borrowing funds, what's best for the circumstances of the individuals. It may be that the individuals have the ability to pay through their own funding options. They may be able to get their own loans that are secured. But in the circumstances where they can't, this is a good option because it's unsecured. It gives bodies corporate access to funds they need quickly to take care of. It's usually something that has happened that's unexpected. It might be a fire safety issue in particular is where we see these sorts of things where defects have come about and they need the money fairly quickly to fix it.
So I think it's probably fair to say it really has to be part of a holistic discussion. So as we said before, or as Nikki raised before, you don't want to create a situation of, you know, short-term gain and long-term pain. So that whole ambit of things like, you know, changes to budgets, special levies, borrowing, putting all those things out and letting the committee and the lot owners make a reasonable decision about what suits their scheme.
Exactly.
Well said, guys. And this is why we've got strata professionals that have been in the industry for a really long time to answer and help navigate through this incredibly peculiar time for us all. I'd like to take the opportunity to say thank you for giving that detailed account and your experience. We want our customers and also for our subscribers to understand that we're having to digest a lot of information very quickly and the situation changes rapidly. We skill up our staff at Archers, you know, weekly on these changes, and we're here ready to help. I know that at your law firm, you're very across all of the details. So if ever we can be of assistance, we're always available. Now we get to the important stuff, answering your questions. I know that there isn't a lot of definitive answers at the moment, but what we've asked from you is to provide all your concerns via our survey. We've grouped them into 4 key areas, and even though we might not be asking your individual question, it's reflective of the common questions that were asked us to answer. They are concerning health, specifically on COVID. Financial questions were obviously in the top, a lot of questions that were asked, and also administrative questions. So what I'm going to do is provide one on each of those and get our learned experts here to give us some answers. So the first one that I want to throw over to James is, are there additional cleaning requirements that are imposed because of the COVID-19 pandemic?
Thanks, Nikki. I think it's fair to say that in most cases there will be. Part of what SCA Queensland has tried to do is provide resources to its members in the greater strata community to help them navigate these types of issues. So SCA Queensland has prepared and updates on a regular basis the best practice guides for COVID-19, and they will outline issues such as enhanced cleaning and sanitisation requirements on scheme land.
Thank you, James. And it is something that we need to continue to assess. I know from a business perspective here at Arches, we've increased a lot of our cleaning methodologies when it comes to protecting our staff and ensuring that our boardrooms are meeting the requirements that are imposed by the government at this current time. And another question for James, specifically related to the COVID-19 pandemic, is a very commonly asked question: when can I use my pool and my gym in my complex?
Yeah, thanks, Nikki. This has been a really common question. I can understand that a lot of people are interested in when pools and gyms will be reopened. It's been an issue where I feel that committees have probably borne a lot of the brunt of the frustration around this. We talked earlier about the 4 tiers of government, and it's important to remember that committees are trying to help their schemes navigate through what can be, federal, state and local government requirements around the health of the residents in their scheme. So they're not trying to be misers, they're just simply trying to ensure that the body corporate complies with those health directives. And those health directives are changing all the time. At Strata Community Association Queensland, we've put together a best practice COVID-19 guide, and we update that as the health directives update. So it's constantly changing. Best place to look is to those best practice guides, and if you need further information, to then look further into the health directives themselves and make reasonable decisions for the health of your residents.
Well answered, and I can empathise with residents that want to use their pool. However, the maintenance costs of maintaining your pool and it not going green still remain, even though you can't use it, which is why you need to continue to pay your levies, unfortunately. But hopefully we're on the right track to recovery now. I can also make a point that it's great. We're very fortunate here at Arches to have Vice President Grant and also the time of the President to give us information that we can post to our Smart Strata subscribers and give you the information as quickly as it gets posted out. So make sure, if you're not a subscriber, that you subscribe so that you can get that information as and when it gets released. Okay, so almost through our big questions. We have one now on financial. Now this is, it goes more to what we were touched on before with the pool and the continuing costs of the body's corporate to continue to maintain shared facilities. And I'm going to get Grant to answer this one. We got a lot of questions on payment deferral options due to COVID-19 hardship. And specifically, why can't a fee or a levy be deferred when other maintenance payments might be deferred in the short run? Grant?
Great question, and it's being asked repeatedly, particularly if you put it into context, if you've got an electricity bill, you've got the electricity $200 rebate that's being given to all people that receive bills. Now, with the body corporate, you've got multiple parties that are receiving payments for services. A lot of those, well, all of them just about are essential services. As you mentioned, you've got the pool maintenance, you've got lift maintenance, you've got grounds maintenance, all these things that need to continue. So what the government has done instead is provide these temporary relief measures within the legislation. So it's deferring the interest, giving the ability to consider sinking fund, capital project deferral as well, and the other items that we mentioned previously.
Excellent. I think that the financial piece of the puzzle for a lot of committees, it differs amongst each building. We have several buildings in areas that are hot tourist destinations, such as the Gold Coast, Sunshine Coast, Cairns and the Whitsundays. And we find in a lot of those buildings, there's a lot of owner investors that are heavily reliant on tourism. So I know financial impact of this is our clients are suffering, but we're hopeful to give you the right information so that the committees can make a good value judgment based on what's good for the whole. So I think with education comes that understanding. There's lots of questions on financial aspects that we need to navigate in these uncertain times. The final question that we have, which I find very interesting, and there's a lot of things that we can actually tell you of how to do this, and it exists outside the current situation with COVID. It's an administrative question, which is, what if I disagree as a lot owner with the Body Corporate Committee's decisions? What avenues are available to me? I'll firstly get Grant to give his perspective on this.
Yeah, so the main types of disputes that we see, there's the 4 Ps that we come across quite commonly, which is the pets, parking, parties and passive smoking. So within the COVID-19 period, what we've seen an escalation in is the passive smoking in particular, with people being at home, using their balconies a lot more, be it to have breakfast whilst the neighbour's smoking and that impacting how they're living their life, and also the noise aspect. So that's impacting people as well because they're home more often. So we are seeing some more complaints about those sorts of items, but it's also considering where the complaints originating and what avenues you have to resolve that. So if it's a bylaw breach, then there's a process to follow through that. If it's a legislative breach, there's another process to follow. So it's categorising what the areas are, and the Office of the Commissioner and Community Management do a great job in providing a lot of information on their website, also their free call hotline. And depending on whether it's a complex dispute, sometimes it can be solved quite simply by if it's a parking dispute, stopping parking. But if it's a deeper issue, then you might need to get some individual legal advice about the matter. Someone like James, of course, is there to provide that sort of guidance where it might be a bit more complex, where it needs to put forward a motion to change something that's already within the bylaws for the scheme.
Great segue, because not only do I see my body corporate managers try to resolve a lot of disputes for committees, and a lot of it's education, which we can go a long way to helping you with, and that's why things like SCA's guides and information, Commissioner's Office, and also Smart Strata providing that education to these volunteers is really important. But James, I'd really like your view on when something does become litigious in nature, what are the processes that need to go through, and where should committees draw the line between trying to resolve an issue themselves and then or choose to engage your counsel?
Yeah, certainly. Thanks, Nikki. I think it's inevitable that there's going to be disputes in bodies corporate. You can't put that many people together and give them this many complex situations and expect that everybody's always going to see eye to eye. And because of that, you really need to plan for disputes. So some schemes may want to consider having dispute resolution plans rather than responding in the moment when the heat of that particular decision is on. Grant made great reference before between different types of disputes. So some things can be kind of structural in nature, in the sense that you might need to amend the bylaws to alleviate that particular situation, and some things might be down to technicalities around meeting procedures. I think often in strata, parties get emotionally charged. It's the only area where you have these intense disputes. You go off and litigate, and then you get to live next door to the people who you just litigated with, and via the body corporate, you all get to share in the cost of that. So take some caution. All of the jurisdictions that are available to you, for the most part, the first step of that is self-resolution. And I don't think that step should be overlooked. So try to look at how that problem can be solved through conversation, through working with the parties. One of the things that we said at SCA when COVID-19 first started was, let this be the thing that pulls us together, not pull us apart. And as Grant said, unfortunately, with people living in such close proximity under these conditions, it is easy for tempers to fray. So self-resolution is absolutely key, not just as a ticker box exercise to go off and make your Commissioner's Office application, but to really try and resolve that dispute. It's not about being right, it's about getting the right outcome for all lot owners. If unfortunately self-resolution doesn't work for you, then for certain types of disputes that are around potential breaches of the legislation, then you can make a Commissioner's Office application. For other more complex disputes, and we talked about things like potentially enhanced cleaning around the complex, if that results in a dispute with your caretaker, then that's likely to be a complex and contractual dispute that might need to go to QCAT or go to court. Really important to get proper legal advice before doing anything in relation to those types of matters, because apart from the disharmony, there can also be really high costs, and you could be years and years in court over those types of matters. So really implore people to try and converse first, try to self-resolve before going and commencing proceedings. I might throw back to you, Grant, for your sort of expertise there in what happens when you're dealing with these at the coalface.
Yeah, so unfortunately we usually get notified of a dispute once it's gone too far. Now, what you've mentioned about the communication, you need to communicate in the right way, and sometimes it might be letting your neighbour know that if it's smoking on the balcony, in a respectful, polite way, letting them know that that's impacting your breakfast, your lunch, your dinner, whatever it might be, because they might be just blissfully smoking their heads off on their balcony and not know that you're even there. Or on the flip side, we hear after the fact that somebody's yelled out over the balcony and all these sorts of things. You've got past that point of being able to go to speak with them and explain what your position is to try and get a peaceful outcome, because, heels get dug in and it starts to become a dispute. So from the get-go, it's considering the language you use, the communication style, and working together as a community to try and, with your neighbours, as you've mentioned, you don't want to end up suing, living next to somebody that you've just sued, to try and come to a compromise. There's give and take living in close proximity.
Excellent, a well-rounded answer. So I think to summarise from the general body of questions that we got from the survey, there is a lot of uncertainty out there for you. We have provided some answers which were present prior to the pandemic, and then some which have been supplied through the temporary legislation. I thank you for tuning in, and I also thank our industry professionals, James and Grant. It's good that people will contribute their time and try to educate the different stakeholders in our industry. It's definitely an interesting industry to try and navigate, and I know people new to it find it difficult and overwhelming. I know I did. So go to Smart Strata, call Archers, call our industry sponsors, anything we can do to help you. We try very hard to think about the answers that you need to the questions that you may not have asked, and hopefully we can do another one of these. Now for the exciting part, where we get to draw our lucky door prize, where a lucky person that's been in attendance today and also given us one of these great questions get to take home a Google Home Hub. I'm going to get Grant and to draw, just so you know, you're all in here.
And the winner is Belinda Russo from Sea Haven.
Congratulations! Our team will be in contact with you to organise the delivery of your great prize. Remember, you can contact us through Smart Strata, through the Archers website. We also have Facebook and LinkedIn where we post a lot of information, and we'd love you to see it and hope that it's of relevance for you. Be sure to stay tuned over the next week so we can give our sponsors prizes away, because I want you all to be lucky winners. Just to wrap up, thank you again to our sponsors. Thank you to our guest presenters today, and I hope that we've given you some practical tips on how to actively connect with your community during this time and stay connected.